Resuming debate, the honourable member for Vancouver Kingsway.
Thank you, Mr. Speaker. I rise today to speak about Bill C-31, a bill that dramatically changes the refugee system in Canada and, in my respectful view, does so for the worse. As you know, Mr. Speaker, I was our party's immigration critic when this bill was introduced some 3 short months ago. And following the introduction of this bill, I can tell you I was inundated by Canadians, ordinary Canadians and stakeholders alike, who were worried and shocked about what this government was proposing. Mr. Speaker, it is no exaggeration to say that this bill is opposed by every single major stakeholder group in the country. Churches, doctors, immigration lawyers, settlement service organizations, academics, refugee groups, cultural organizations, refugees themselves. Rarely has a bill been so roundly condemned by so many. Why? Because, Mr. Speaker, it is readily apparent to anybody who studies this omnibus legislation that this bill is unconstitutional, it's punitive to refugees, and it will be completely ineffective at deterring human trafficking. And I must say, Mr. Speaker, that I'm extremely disappointed to be back here at report stage after the committee, the Standing Committee on Immigration, and Canadians heard many hours of very trenchant and damning testimony. I'm disappointed to hear that the government has ignored the recommendations of over 40 witnesses representing the full spectrum of the immigration community who warned about the damaging and misguided effects of this bill. I'm referring to witnesses such as the Canadian Pediatric Society and psychologists who warned of the effect that mandatory detention will have on refugees who have been traumatized by persecution, violence, torture, or other atrocities. The government ignored this testimony and is moving forward with this backward approach. Most tellingly, those same groups testified about the particularly damaging effects that detention has on children, which this bill will also see the detention of. I'm thinking of the testimony of Peter Schowler, Lorne Waldman, and other members of the Canadian Association of Refugee Lawyers, probably the most knowledgeable group of people in this country on refugee law. Peter Schowler used to be the head of the Immigration and Refugee Board, who testified that the accelerated timelines to make refugee claims will be impossible to meet in an adequate manner. In their testimony and their experience hearing cases, this will lead to mistakes and decisions not to grant asylum to bona fide refugees. And I want to pause, Mr. Speaker, and tell you this. Rarely is a mistaken decision more damaging and dangerous than a mistaken decision in a refugee determination case. Because to be a refugee, you have to show that you have a well-founded fear of persecution. This often means that you're fearing for your life. And so a wrong decision can lead to a deportation of someone back to a country where that person may face torture, persecution, and death. And, Mr. Speaker, that has happened. In the past year, there have been cases. There was a case recently of a Mexican refugee claimant denied here, sent back to Mexico, who then was murdered by her ex-husband, who was a police officer who she was claiming was persecuting. Those lawyers also spoke of how the provisions for mandatory detention, arbitrary designation of irregular arrivals, denial of appeal to certain classes of refugees, and ignoring the best interests of children go against our own Constitution and international conventions alike. The government, unfortunately, ignored that expert testimony. I think of the testimony of Gina Chani from the Roma Community Centre in Toronto, who spoke of the real human rights violations and systemic discrimination in Europe. She spoke about how Roma refugees would be negatively affected by having EU countries designated as safe. She spoke of how disheartening and insulting it is to hear our immigration minister refer to them as bogus and explained why he is wrong. Mr. Speaker, I want to pause there and just say we all are very intimately familiar with the persecution, the genocide against the Jewish people in World War II. What is less commented upon is the fact that Roma, along with the disabled, were also targeted out for their ethnicity, rounded up, tortured, medically experimented upon, detained in concentration camps, and murdered simply because they were Roma. This is not just any ethnic group, Mr. Speaker. It's an ethnic group with a history of being the victims of genocide in Europe. And there is absolute rock-solid evidence that Roma still face persecution, and states that are unable to protect them right today. The government ignored that testimony. In fact, they doubled down and continued to use inflammatory language referring to Roma refugees as bogus. We heard from Chris Morrissey and Cheryl Lynn Jordan from the Rainbow Refugee Coalition and others who spoke about how the so-called safe country determination process threatens LGBTQ refugees specifically. Over 100 countries of this world have some form of legislative discrimination against the LGBTQ community, including death in some countries. Again, the government plows forward as though these stakeholders never spoke. Experts from Australia, a country this government likes to selectively quote from when they're adopting policies that they like, testified that the draconian rules that this government is imposing to try to deter human smuggling, that is, rules that direct punitive elements at refugees, have no deterrent effect at all. Australia has adopted the same procedure that this bill does, and there has been no diminution of refugee claimants coming to the shores of Australia since they've adopted those rules years ago. The government ignored that evidence. Now, the government did make two important changes, and I think it's important to point that out because it shows what an effective official opposition can do, and it shows when parliamentary committees work. Witnesses and opposition members warned about the impact of Clause 18 and 19. These clauses would allow the minister, through the IRB, to strip permanent resident status from people who have been living in Canada for many years on the basis that conditions have improved in the countries they fled. Now, the minister said repeatedly that this was not his intention. Actually, he went much farther than that. He said that the bill categorically did not have this effect. He vociferously and arrogantly derided members of Parliament and stakeholders who brought up this subject. In the end, however, he realized and acknowledged that he was wrong, that he did not understand the effect of the bill that he wrote, and he has still not apologized for this vitriol and derision with which he so wrongly defended these clauses. The other change that the government agreed to was to require a review of the mandatory detention at 14 days and at 6 months. This came after witnesses, including witnesses sympathetic to the government, had a consensus that this provision was blatantly unconstitutional, as the New Democrats pointed out for months. This means that the government put forward a bill and could not find one expert in the whole country who deemed it to be charter compliant. This is shocking. I would also point out that the intransigence of the minister, who insisted throughout that this bill was constitutional, repeatedly, only in the end to find out that just like the official opposition said, and stakeholders said, and the legal community testified, it was not constitutional. This change notwithstanding, Madam Speaker, however, experts still believe that other provisions make this bill unconstitutional, and we may be tied up in the courts for years figuring that out. Madam Speaker, I want to step back and go back to the beginning and ask this question, why? Why this bill? Why does the government insist on going forward with this bill when many of the problems the government claims to be addressing were already dealt with in the previous Parliament in Bill C-11? We dealt with them when all parties, the Conservatives included, came together and passed the Balanced Refugee Reform Act. We all recognized that the refugee determination system was slow, and we put forward reasonable solutions to this problem. The minister himself stood in this very House and praised Bill C-11. He said that the amendments that were worked out by all parties in the House made the system faster and fairer, and he called that legislation a monumental achievement. When I asked the minister whether he was wrong then or wrong now, he said he was wrong then. Well, Madam Speaker, that may be honest, but it does not inspire confidence, and it raises serious questions about the real motives behind this bill. Why would the Conservatives throw in the trash can a bill that the minister praised and reintroduced a bill that, in previously unamended form, that even the Minister of Immigration, said was inferior? One part of that still puzzles me is the minister's insistence to give himself the power to unilaterally declare a country to be safe. Under the C-11, designated persons still have the right of appeal to the Refugee Appeal Division under this legislation. They don't. Under the previous legislation, the minister had to consult with a panel of experts before determining a country to be safe. Under this bill, he does not. On television, the minister said that he had run simulations that showed that the system under the previous bill would not work. But when I've asked for the data from these simulations, even under access to information, the minister cannot produce that information. Madam Speaker, there is no need for this bill. Canadians know it. The official opposition knows it. The immigration community knows it. The government should withdraw this bill now before serious damage is done to refugees and Canada's reputation as a compassionate country. Thank you.